Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you for joining the Jury Thinks What. This is a podcast by trial lawyers for trial lawyers. I am Saul Gruber, your host from Gruber Trial Consulting, and we are available everywhere you get your podcasts on the Lawyer Minds ecosystem. Today, we have a great guest, Brian Jasper, who works at the Thomas Law Firm and handles nursing home cases, among other types of cases, really all over the country. Brian is one of those lawyers who goes under the radar and has brilliant ideas to go along with his brilliant verdicts. I think you're going to really enjoy this interview with Brian and really listen to the cross-examination that we end the interview with. It's actually a live cross-examination of a nurse, which was just a home run and a $5 million plus verdict in Kentucky. So again, this is Saul Gruber, and listen to Brian Jasper on the Jury Thinks What, a podcast by trial lawyers for trial lawyers. Thank you. And you're listening to the Jury Thinks What, a podcast by trial lawyers for trial lawyers. I am Saul Gruber, the host from Gruber Trial Consulting, and pretty excited that we have the Brian Jasper. And I like to kid with Brian when I say the Brian Jasper, because there are 8 of us who know who he is. And despite the fact that he has multi-million-dollar verdict after multi-million-dollar verdict after multi-million-dollar verdict. Brian, thank you for joining the podcast. How you doing today?
I'm doing great, Saul. Thank you for having me. I'm looking forward to this.
So, Brian, you and I have known each other for a number of years. You've been lucky enough to be actually in my video for my webpage, since it was done in your office, and you're at the Tad Thomas's law office. So that's one of the things you have that nobody else has.
I don't think I got an IMDb credit for that, but I am very proud of that. Crowning moment.
So Brian is a nursing home lawyer, and anybody who's a regular listener of this podcast knows that I've always been a nursing home lawyer. And one of the things we love to do with this podcast is bring our brethren on and talk about different things that we deal with on a daily basis. So Brian, you have one up on everybody because you are also a nurse. Is that true?
That's correct. I went to nursing school back in from 92 to 93. Got licensed in Kentucky as a licensed practical nurse and worked in long-term care. And I was part of the team that opened the first hospice inpatient unit in Commonwealth of Kentucky back in 1995. So
wow,
did that for about 13 years.
So how do you go from being a nurse and actually doing God's work, right? Especially in nursing homes and places like that, to become a trial lawyer, who some would say is doing the non-God's work? How does that happen?
It's an interesting story. I loved being a nurse. I felt like I was one of those people that were cut from that cloth to take care of people. I enjoyed taking care of people. Being a male nurse at the time that I became a nurse in Kentucky was still an anomaly. There were 2% of the nurses in Kentucky in 1993 were male, and I was part of that 2%. And but I'm a big guy, played football. I could do the transfers and the lifts, and I was in the room at the bedside taking care of my patients. And it's hard work. You've seen it throughout your career. Most places are severely understaffed. Their people are overworked. And after doing 12-hour, the last 3 years that I worked as a nurse, I worked 2 16-hour shifts on Saturday and Sunday so that I could be free during the week to go back to school and finish up my degree. And so, when I went to law school, I'll be honest with you, I was going to be a criminal defense attorney. I watched television shows and thought that was where the excitement was. And I did not until I clerked during my summer clerkships that I realized that I could bring my 2 careers together. I spoke the language. If you read medical records and understand medical terminology, and you, when you read something in a nursing chart and you say, hey, I've done that 1,000 times, I know how that should be done with the proper way to do it. It just, it was the perfect combination. And honestly, I think about it like this. I'm still taking care of patients. Most of the time in my cases, I'm taking care of their families,
Right.
but that was part of taking care of patients. You took care of them and their families, you know, gave them explanations of what was going on and things like that. So this is really just a continuation of the previous.
I mean, knowing about reading charts, because I still read charts every day of the week, it must give you such an advantage to be able to actually read a chart and almost visualize the nurses doing what they say they're doing.
It also helps when you read a chart and you know that it's complete garbage. You know, when you can find that documentation that you could say with a 95% certainty that didn't happen. They didn't do that.
Right.
Or just like you said, reading it, being able to visualize it and understand the steps that were missed or the interventions that they should have had there. Yeah, it's definitely an advantage. And I've tried to use that and bring a new perspective to my trial team, you know.
Now, what's interesting is, so I know pretty much fresh out of law school, you worked for the behemoth, as we call them in our business, Wilkes and McHugh. They are the behemoth of nursing home lawyers, at least were for forever, until really just recently, where they've kind of flared out to other things. How did that come about?
I was hired by Wilkes and McHugh in my third year of law school. I was sort of a unicorn. They usually didn't hire new graduates, but given my nursing background, especially in long-term care, I guess they saw that I had a good perspective to bring to their firm. I clerked with Beasley Allen in Montgomery, Alabama, for both summers during law school. It was
Talk about a behemoth.
A great privilege to work. I got to see Jerry Beasley do an opening statement in a case as in between my first and second year of law school, and it was just an outstanding experience. You know,
yeah, that's pretty magical stuff right there.
He's a lion of the bar. I mean, he's a fan, and plus just a really wonderful man. Treated me really, really well. The whole firm did. And in fact, one of the attorneys that I worked for that sort of helped me there was an attorney with Beasley Allen that had nursing home cases there in Alabama, and I helped him survive a summary judgment in the case. I helped him write a response, and it was quite a thrill. He took me to court with him while he argued to the judge the points that I brought up to him, and sort of explained. And it was just really a thrill. And I realized I wanted to do nursing home work when I graduated from law school.
You caught the bug early.
I did. And J.P. Sawyer was his name. He's now independent. He doesn't work for Beasley anymore, but he passed on my resume to Wilkes and McHugh, and they called me up and flew me down, and I was able to interview with them. And I will always be grateful to Wilkes and McHugh for being patient with me and spending a lot of time teaching me how to be a lawyer. I knew how to be a nurse. I knew how to read the charts, but they really taught me how to integrate that knowledge into the litigation process.
One thing I've noticed a lot, and I don't know if you have, lately, I see a lot of lawyers skipping that major step that you did, and quite frankly, I did. I came onto the scene in 1988, worked for a firm that I had a mentor there, that they gave me cases. They said, go try them, just figure it out, because it doesn't matter what book you read. It doesn't matter what I tell you. Until you get into that courtroom and are faced with this, you're not going to know how to do it. But I see a lot of lawyers now who are jumping out and becoming entrepreneurs, which is great, but maybe you're missing that step of having a mentor and learning how to be a lawyer, especially a trial lawyer. How important was that to your career?
I can't even put a value on it. It was that valuable to me. Wilkes and McHugh, luckily, was of the size and type of firm where they could support a young lawyer in his learning phase. And I didn't take over my own case until I'd worked with them for about 11 or 12 months. I mean, it was almost a year before. And then they gave the case to me and another young attorney who has become a pretty high-powered attorney himself, Ross Mann. We worked together as a team.
I'm certainly familiar with Mr. Mann.
Yes.
He's one of my peeps.
Yeah, we worked together as a team initially, and that was another brilliant move that our
So you work with Ross. You were teammates with Ross?
I did. Ross and I were
teammates.
We co-litigated cases because Ross had been a personal injury attorney and he understood litigation I had been a nurse and understood all the medicine. So we basically taught each other we're sort of like symbiotic, yin and yang there. And
As you know, Ross is a client of Gruber Trial Consulting. I did not know that you guys were teaming. I knew you're friends. I didn't know you were teaming. Yeah, Ross is so much fun to work with because he's got this open mind. He has an idea about everything. And as soon as you sit down and talk about it, he's like, "Oh, my idea sucked. Let's do this. This is so much better." And we would just together, just symbiotically come up with ideas for openings and closings that really worked well.
Ross is a great attorney. There were days when I would get 40 to 50 emails from Ross with questions. I mean, he's a very inquisitive, very curious guy. I put his knowledge of the medicine now up against mine or anybody else's. I mean, he's pretty fantastic.
I'm aware of the constant Ross emails. Actually, I do know that. I do know that. But this is about Brian Jasper. So you work with Ross, and you're lucky enough to be in the Kentucky office of Wilkes and McHugh, which just spawns great lawyer after great lawyer.
That's true. I've worked with some of the greatest. Was witness to some pretty large verdicts. Worked with some outstanding attorneys. And I'll step back real quick and just throw this in. The day that Wilkes and McHugh hired me, I had lunch with Tad Thomas, who's now my boss. We were connected through Beasley Allen. Tom Methvin, who was the president of AAJ, told me that if I was going to practice in Kentucky, I needed to know Tad Thomas. So I had lunch with Tad, and Tad would tell me over the years while I was working with Wilkes and McHugh, because I would send car wreck cases to Tad, and we would meet every once in a while, and he'd say, "Go learn how to do those nursing home cases and come work with me." And by chance, by luck, I got to work with him.
And now here you are.
Here I am.
Partner of the Tad Thomas Law Office. Your guys are you're in Louisville.
We're in Louisville.
In that cute little area right outside of Louisville, right? What is it? What town are you in?
It's called Norton Commons. It's part of Prospect, Kentucky, just a suburb of Louisville. That's right.
And now that you're working with Tad, I guess getting your own cases isn't that hard.
Not at all. Got plenty of cases, but I've got good partners here too. So.
Oh, you have great partners there. It's a great firm. I have a lot of fun working with you guys. And as you know, Tad is a very old and good dear friend of mine, which is why I loved having you, because Tad would tell me about all the things you two were doing in your trials. And it was one interesting thing after another. And I said, I got to get Brian on because we need to talk about this stuff, because this is what makes our practice better and makes us better lawyers, is listening to you, listening to Tad about all the things you're doing that's different than things we did 20 years ago, and how much better it is and how exciting it is.
Sure.
So the last couple of years, you've been trying a lot of cases.
That's true.
Tell me why you think that is.
Well, we have tried, Tad and I have tried 2 cases to verdict in the last year and a half, last 2 years. And I think at first, I don't think they understood who they were dealing with. They didn't realize what kind of trial lawyer Tad was. They learned real quickly. But Tad's the type of attorney, he's a true blue in his genes trial lawyer. He wants to try cases, and he's happy to try cases. And we have developed a process here to pick good cases. And so if we don't get the right offers or cooperation, we'll go to trial. We're not scared one bit.
Yeah. I had Steve Levin, who I know you know, on a few months ago. And he said the way they look at that, Levin and Perconte also have a national type practice, as do you guys. And they look at all their cases, whether it be nursing home, med mal, products, it doesn't matter what it is. They're not trying to get money out of the insurance company. The insurance company is trying to get a release from them. That's the way they approach every case. I like that. Right? It changes the whole fundamental way of thinking. And Steve says, as long as they pick the right case, they have the number. And if the insurance company wants to pay their number, they're thrilled to take it. Sure. But if the insurance company doesn't want to, they're thrilled to take it to trial, and they're willing to take the risk, as is their client.
Sure. I mean, we try to do a lot of client work on the front end, explaining that.
Tell me what that means. Tell our listeners what you mean by because I think that's so important that people forget. Tell me what you mean by that.
Well, we're in a position here at Thomas Law Offices that most of us attorneys work our cases from intake to resolution. We know the clients early on. We develop those relationships. I mean, it's not just a cheesy slogan. I mean, our motto is where clients come first. We really pride ourselves on that client interaction, but we educate our clients on the realities of the law. And we start to lay that foundation for them to understand the basis, what I call settlement calculus. There's all these variables that have to come in, and they've hired me as their expert to do that settlement calculus. Do the variables favor settling this case early, settling at mediation, settling at the last minute, or going to verdict? And so we're constantly making those calculations and adjustments and giving that advice to our clients from the beginning so that it's something they're used to hearing. They're used to hearing us be very frank, because I talk to them about there's a settlement value and an emotional value, okay?
Right.
I cannot get you the emotional value for your case because truthfully, you can't put a number on your father's death or your mother's suffering. But I can get you the best legal value, and that legal value involves our calculus, all the variables, venue, judge, defense counsel, insurance company, all those things that go into it. So we lay that groundwork very early on and prepare them, so that they can make the right decision when they're put to their decision on whether to settle or go to trial.
And I'm assuming as discovery is ongoing, that calculus may change as well as to the value.
It does, and then that's when it's our responsibility to update them that the calculus has changed, and this is the new variable, and and put it in terms that they understand and understand what the impact on their case is.
Because I always used to hear, well, my mom went in there, she could walk, then she died. So they killed her. So this case is worth $1 trillion because I read that somebody got $150 million in Texas for the same case. So kind of your job is to take that statement from the clients and break it down a little for them.
Right. And that's where I think my training as a nurse, putting healthcare issues into layman's terms is not entirely different than taking legal concepts and legal issues and putting them into layman's terms and helping the client understand what our thought process is and what it means for their case. Because you're right. And one of the problems, it's a good problem to have, I'll take it all day long. If you get positive results, excellent jury verdicts that you collect on, everybody thinks their case is $5-10 million case. And
right.
Just the matter is that it's not. And we do a lot of work to make sure that those expectations are understood in their proper context.
I'm curious, if you don't mind, can you, if you're allowed to, can you break that down and leave it a little bit more for our listeners? When you say you and Lindsay and everybody at the office do a lot of work doing that, what types of things are you doing with your clients so that they can trust you more and understand what you're saying more?
Well, we have a sort of policy and procedure here where we contact our clients regularly. We reach out to them, initiate updates. Sometimes those updates say, nothing's happened. I tell my clients at the beginning of every case that my job is to push a case. The defense's job is to delay. And I'll tell them that at the beginning of the case. And by the time we get to settlement, they go, you were right. All they did was try to delay this.
Right.
And I said, that's because I've been doing this long enough. I know their MO. So my job is to be aggressive in a respectful and professional way so that I push your case towards resolution. And so that regular contact, we have a computer software that manages our production that gives me a reminder. You need to call and talk to the client. And so the biggest complaint I get from cases that I've taken over where somebody has either dropped their attorney or the attorney's withdrawn is that their attorney wouldn't call them, wouldn't talk to them. They never got to talk to the attorney. And so I make that a priority. I'll talk to them. Sometimes I don't have the answers they want. That's okay. If they hear from me and they hear me say, I don't have the answer, but I'm going to get it for you.
Right.
My assistant will call you with the answer or we'll email it to you. They respect that. They appreciate it. They don't expect me to work magic or be perfect, but just hearing from me sometimes is enough.
Do you think, before we even get into how you approach discovery, but do you think the fact that you don't have 150 nursing home cases that you personally handle allows you to reach out to your clients a little bit more?
Absolutely. I mean, managing the number of cases that I have is frankly, here at Thomas Law Offices, I'm very blessed. that I don't have to carry 150 or 200 cases. I don't think that I effectively could, not the way that I want to practice law.
Well, certainly not nursing home cases. I don't think anybody could.
I don't know. I don't see how anybody could keep that many straight. We're very selective here. I tell my clients all the time, no matter what you hear on the news or radio, there really is no such thing as a frivolous medical malpractice lawsuit in Kentucky. We cannot afford to take frivolous cases. We all know the realities of the cost of litigation, the cost of experts, the cost of time and energy. And I tell my clients, I can't promise you I'm going to file your case when I do an intake, but I can promise you you'll get a full evaluation. If the case is there, we're the team to fight your case.
Right.
But we don't have time to take cases that don't have that solid merit. And, as a former healthcare provider, I couldn't ethically or consciously take a case that I didn't sincerely believe in. So I'm lucky that I'm in a situation where the cases that I do have, I can work the way they should be worked, and they're worked by me.
Well, you just said something that was so spot on. Cases you can believe in.
Sure.
Because if you don't believe in your client or believe in the case, it's really hard to do the work we have to do to move the case without that belief.
Right. I mean, that's, and when I say that I believe in a case, it's that I believe that the two primary elements are there, that somebody breached the standard of care and it caused damages to my client. It's, that I have a good, solid, from my evaluation, my standpoint, that I can prove those major elements.
Dave, I don't know. Do you know David Hoey out of Boston?
I've read his book.
Okay. Well, Dave, good friend, past chair of the NHLG, probably about 7 or 8 years before me. But Dave used to say, you need 3 things to take a nursing home case. You need a really good family. You need a really bad facility, and either a horrific injury or an egregious act. And every time, and I agree with that, and every time he used to say he violated his own rule, just the case went south and it became so problematic. Does that make sense to you, that type of protocol?
I agree with that 100%. Those are 3 important elements. I think if you have those, then those are the cases you can really sink your teeth into.
Yeah.
And you really feel good about the energy and the time and the money to really fight for those families.
I want to talk to you a little bit. I mean, I want to get into you guys hit 2 trials in Paducah County. And just the name Paducah brings up different things. That has nothing to do with Paducah, Kentucky, but you think of all different things. Right. And within, would you say 6 months of each other or a year of each other?
One was in August and one was January. So about 5 months. And
what were the 2 verdicts?
The first verdict was $2.213 million with $1.625 in punitives. The second one was a $5 million verdict with $4 million in punitives.
Right. And those are 2 cases that in many nursing home lawyers' careers, they don't have that many verdicts. And you had them in, 5 months.
Right.
So clearly we want to talk about that. Okay. But before we get to that, I want to try to pick your brain a little about discovery, right? You take the right case, you file the lawsuit. What's your goal? Like, how do you figure out how you want to conduct discovery?
I initially learned there was sort of a way in terms of, you depose your administrator, you depose your DON, and then you move on from there. And I've shaken that up a little bit over the years. My goal.
So let me stop you for a minute, just for people who aren't quite sure. I've always said there's used to be a trilogy of depositions I have to take in every case. One was always an administrator. One was always a DON. It used to be then a medical director. Then I didn't care too much about that. Then I became the MDS coordinator. I've kind of come off of that with the new PBJ, payroll-based journals. Maybe the MDS coordinator wasn't that important. And I keep adding to it. But I always used to start with the administrator and finish with the director of nursing. Right. How did you shake it up?
Well, and I still do. I still do take almost every case. I'll end up taking the administrator and director of nursing. But after doing this as long as I have found that by and large, they become veterans of the process. They will fight me at every turn, and they do, and I find that they're very forgetful. They just don't know anything. They're so, God love them. I don't know if it's a condition or intentional, but they just forget a lot. So I really spend a lot of my time. We take in Kentucky, we'll do the 30026 corporate rep, and that is where I identify a lot of the documents from my motions to compel. My favorite class in law school, believe it or not, was business associations. I really, because I was a philosophy major, Saul. I didn't get many business classes. And as a nurse, I didn't take much business. But learning the various companies and learning sort of what I call the Kentucky structure, where, the independently owned nursing homes will have the real estate investment company that owns the land. They'll have the management company, then they'll have the licensee. The licensee pays management fees and pays rent to the real estate company, but they're all the same people. I like
That's
to go.
the New Jersey structure as well, by the way.
Right. Yeah. And I think it's pretty much across the country.
Yeah.
They figured out a way to suck the money away from the licensee into these other companies that it can just poofs into thin air. And so I spend some of my time chasing the money and really pinning down who's making the decisions. And usually there's one person, and I love being in a deposition and asking them, well, when you're doing that, do you put on your real estate company hat and then take it off and put your nursing home ownership hat? And I have fun with it.
We once tried a case, Tori Shaw. I know you know Tori Shaw and I in New Jersey, where same thing. The owner owned the management company, and it was tandem. I mean, it's okay. We went to verdict, so there's nothing confidential. And it was, I forget the name of the nursing home, but he also owned Tandem Management Company. And we look at the contract between the licensee and the management company, and this owner signed both parts of the contract.
Sure.
And we had him on the stand, and he was explaining about it being an arm's length agreement, which is it's all lawyers. All the lawyers listening to this know what that is. And I kind of cocked my head at him. I said, well, how did you go about negotiating with yourself? Did you have like a different hat you would put on? I mean, I was being facetious intentionally because it was so silly. I mean, how did you go about talking to yourself to get the best deal for both parties? And the jury's laughing, and he was pretty tone deaf, but for the same reason. It was just funny.
Yeah. That's a very, I guess that's the structure pretty much across the country for these folks.
So when you do the discovery for that, you're not really talking about what happened to the resident. You're not finding out in that discovery a lot about staffing. You're really trying to find out where the money goes and why it goes in different directions.
I do, because whoever controls the purse strings controls the facility. And this idea that these management companies or these real estate companies are offsite and don't have anything to do with patient care, I prove differently. I want to keep those entities from being dismissed. I'll get a motion for summary judgment on them in almost every case, but by keeping them in there, you sort of show that in some instances it's almost like an organized crime family. These companies give all their contracts to their children and their brothers and sisters.
Sure do.
And it's a very incestuous thing. And so I want to keep them in there because I want the jury to understand that this is some shady business sometimes.
So do you separate the way you do discovery? Do you kind of like do either tiers, or you have the corporate end and then the nursing home end? How do you do that?
I do somewhat do it separately because I learned very early on. I had a brilliant trial attorney tell me that when it comes to nursing home cases, Brian, if you make it about the medicine, you're going to lose. Okay. The corporate case is such a massive part of it. In my own experience, and even in my experience litigating, 90 to 95% of these nurses and CNAs on the floor, they're busting their tail. They're doing the best they can, but a human being can only give competent care to a limited number of patients. And if the people that are controlling the purse strings are not giving them the right patient to nursing aid or patient to nurse ratios, they're going to fail. And really of no fault of their own. as far as on the individuals. So I go directly to the corporate side of it to determine why were you cutting these people off, cutting their hamstrings.
Right. And we used to say that I think the rate is even higher. I think it's not 90 to 95%. I think it's 97 to 98% of the staff are great.
Maybe so.
And doing the best they can and are just placed in a situation that's untenable, that there's nothing they can do.
And I know this, Saul, because I worked those shifts. Okay. I worked third shift skeleton crews where I ran from one end of the facility to the other, trying to answer, G-tube pumps and oxygen concentrators that were going off and call lights. And you just physically can't get it done. And it's devastating. And that's part of what burnt me out on bedside nursing, because very few situations that I find myself where I could truly take good care of my patients.
Yeah. I mean, I used to say, and I don't think you were part of the NHLG when I was chair, but
I was not.
What you just said was my motto. And Dave Couch, who's another, I guess I'm just old. David Couch, who was chair years before me, used to say, it's about the nursing home company, stupid. And I actually made a picture, a painting of that, put it on my wall. So every time I started to talk about deviations of care and standards of care and things of that nature, I had to keep remembering, well, it's not their fault. If you have 30 people you have to turn and there's 2 of you, you're not going to turn 30 people. I don't care what the standard of care is. You're not doing it because it's impossible to do.
Right.
And yeah, so you deal with that. But at the same time, are you also dealing with the nursing? I mean, you still have to prove duty, breach, causation, right? Tell me how you're doing that.
Well, something that I've been working really hard to educate judges on, especially in, most of our cases are not a situation where a CNA or a nurse slapped a resident. Okay. That's obviously abuse. That's easily defined. Witnesses see it. Slam dunk case. Most of our cases are the result of repeated failures in the standard of care. When a resident becomes dehydrated or malnourished, it's not because they miss one meal.
Right.
It's because they miss 50% of several meals, because they're not staffed well enough for somebody to sit down and ensure that the resident gets enough fluids or eats their food or gets the assistance they need to get the food into their body. Bed sores. You miss one turning round, generally you're going to be okay, generally. But it's when you miss, if the person's supposed to be turned 12 times in 24 hours, when you miss it 4 times out of that 24 hours over 4 or 5 days, next thing you know, you got an unstageable wound. Those repeated failures are not just one CNA's fault or just one nurse's fault. It happens over time, and it's a symptom of the poor management of that building. Their priorities are wrong, and so that's what I focus on proving, is that it's a systemic problem. It's not because one CNA had a bad day and didn't do what she was supposed to do. It was because all the CNAs that work in that place are having bad days because they're stretched too thin. And getting the judges or even juries, if you're presenting to a jury, to understand that, it takes the onus off of them blaming what we now are calling our heroes, our frontline healthcare workers, and blame the companies that are, again, sucking away all their resources.
I don't think I've seen a big verdict yet. And remember, I'm in this 33 years now. I don't think I've seen a big verdict yet where it was big because they were pissed at nurses. Exactly. Or it was big because they were pissed at the aides who couldn't do their job. I mean, it's normally because when I say they, I mean the jury is upset because they realize pretty quickly that the reason that these nurses and aides can't do their job is because they're not being allowed to do their job, and they're as big a victim as anybody else.
That, and when they catch them doing nefarious things, committing fraud.
Right. Changing the record.
That's big.
So how do you go about proving that? And then we're going to jump through to, in discovery, how do you get that information?
In terms of the staffing and the repeated breaches, a lot of it is the record, but a lot of it is getting a hold of the budgets and holding the administrators accountable. I haven't had an administrator probably in years tell me, that they did their budget at the facility level, I mean, it's always above them. It's always handled by the business office in some other state, things like
Right.
that. You know, they always say that they have input, but they don't have final say.
Right.
We really dig into we get the daily staffing sheets,
Right.
and we do punch detail analysis to show that a lot of times what they're trying to say on the daily staffing sheets, well, that person never clocked in, and there's no time clock adjustment form to say that they did clock in, they just forgot, you know, and we're able to show that there's not as many people on the floor as they're putting up on their daily staffing sheets.
Got it. So for you, it's those punch sheets from payroll that are really showing us who was there, not what they write on the schedule.
And the reason that is because CNAs and nurses, they track that down to the minute. If you screw up their paycheck, they're in there letting you know. And so I tend to put more confidence in those, because if they were off, then those CNAs and nurses throw a fit and try to get them fixed. So I put a lot of confidence in those being true, because there's not just the accountants looking at that, there's the actual employees looking at it and auditing them.
And I've always said at trial, it's just so weird. There are literally two different trials being put on in a nursing home case. There is the plaintiff trial where they're talking about the systemic issues and the lack of staffing and the lack of care. And then there's the defendant's trial, which is comorbidities. They were an infection waiting to happen, that it's like two ships passing in the night. Have you found the same thing?
Absolutely. I've been blown away by the defenses, because they seem to be, I don't see the factual support for the defenses that I've dealt with in trial.
No, I've never seen the factual support for most of the defenses. They just, especially if it's a med mal lawyer defending the case, all of a sudden they're arguing over blood values, and you're like, wow, a blood value in a pressure wound case, okay, unless it's something nutritional, I'm shocked that we're even dealing with this. And I would just keep banging home the schedule. You know, that was always my cross.
Yeah, that's pressure injuries don't happen absent pressure. The pressure, it's a pressure injury. I mean, all the other factors there are, and I've heard the stool analogy. You've got to have nutrition, hydration, and, you know, all that stuff, skin protection, proper cleanliness, as well as pressure relief. But the other three can be terrible. But if you're relieving the pressure all the time, you know,
Right.
I took care of patients for 6 years in inpatient hospice units, people that were at the end of their life, actively dying within 2 weeks of death. They hadn't eaten or taken in significant fluids in days, and they didn't get bed sores, because we had proper mattresses and we had proper staffing to keep them turned and repositioned and their pain controlled. They can be prevented. I firmly believe it.
No, yeah. I mean, listen, there are some that are just going to be unavoidable, right? Certain end stages. Some are just unavoidable, but for the most part, I think if you do what you're supposed to do, you can avoid them from becoming a stage 4 infected septic death ulcer.
I think the ones that you would call unavoidable are so rare. They're a lot more rare than the defense bar would have us believe.
Well, that's an understatement.
But I like I said, for 6 years of having inpatients, I cannot remember a bed sore that developed on our unit. And we would have people for 2 or 3 weeks, the last 2 or 3 weeks of their life. It can be done. But again, we were well staffed, and we took excellent care of those patients in the final days of their lives. And so sometimes we'd get patients in from home that already had wounds developing, and we would address them. But I get my hackles up and I fight those pretty hard. That unavoidable pressure wound that just goes right through me.
So how many depositions do you think you're doing in your average nursing home case?
I'm taking, by the time we get to mediation, before experts kick in, I'm probably taking on average 5 to 6.
Okay, that makes sense.
You know, your standard admin DON. I will take sometimes. A big trend that we're seeing, and I'm sure you're seeing this, is the nurse practitioner that's in the building
Right.
5 days a week. A lot of times I'll start taking them because they do depend on the nurses to be their eyes and ears, not as much as the doctors, but they're also in there. And I get some really good admissions out of nurse practitioners.
And I would think what I've seen is they're in there and they know what's going on in there.
Sure.
And more often than not, the nurse practitioner is not going to put his or her license on the line,
right,
to protect any company.
No. And they are supposed to be, I'll establish with them that they're supposed to be patient first.
Right.
What's best for the resident is what you have to do. And I'll get some really good admissions out of them on what they expect as far as turning, repositioning, nutrition, hydration, infection control, things like that. They're pretty good about that stuff because they work in nursing homes and they know what you have to do.
So now we shift a little into the trial phase. And I know you've tried those couple cases with TAD, and obviously you've tried cases before you've worked with TAD. How do you determine what you're going to talk about at trial and who you're going to get that information from?
We, like most trial teams, we have a lot of trial team meetings to determine order of proof, to determine our witnesses. I personally keep a running checklist in my trial folder of each witness that I'm responsible for and what exhibits I need to get admitted through them. I basically have a box check system to where when I'm doing my direct examination to get those particular records or those particular documents admitted under them, I keep a list. I think that's pretty standard among all trial lawyers. But in terms of deciding what we're going to talk about, our strategy is similar to everybody else's on direct examination. You need to get your story told. You need to frame your theme, get your theme out through repeated questions through your witnesses.
Right.
But something we do a little bit differently is the way we cross-examine people, and we can get into that when you're ready. But that's really
we're definitely going to get into that.
Okay.
But one of the things, and I've talked to Tad about this, and I've talked to a lot of people, but I know before your first trial in Paducah, they gave you what, like 2 days to try the case, whatever it was, a week for the entire trial, if that.
A week, yeah.
And Tad and I were just I think we were out to dinner one night. We were just talking about it. Certainly, I wasn't in on the case in any way.
Right.
And he was just trying to hone down the entire case. How do you go about doing that?
Well, something we learned from that case and getting prepared for it, because we had such a limited time frame, we started talking about what juries would like or not like. Okay, we're in a time frame, we're in a soundbite world right now.
Right.
People, YouTube videos that are longer than 5 minutes. I don't know what the statistics are, but if a YouTube video is longer than 3 minutes, the viewership goes down dramatically. People, you need to get in and get out. And one of the ways that we honed down and really made our case very tight is the use of technology. Tad's a tech guru, you know this. I mean, we in that trial were able to present evidence and present witnesses in a very seamless. The other side, and for lack of a better term, bumbled and fumbled with poster boards, and they had things blown up, diagrams, records, all blown up. Whereas Tad hit a button and it came up on the screen. He was able to point and highlight, use it with witnesses, the efficiency of it. And we were very careful not to be overly repetitive. We were very careful about, we had bombs to drop. And
Right.
If they were nuclear bombs, you only need to drop a nuclear bomb one time, or maybe two. You drop those bombs and then you remind them in closing, rather than just pounding that bomb so that it loses its effectiveness.
It's interesting because we have always been told as younger lawyers, repetition. Tell them what you're going to tell them it, and tell them what you told them, right? Until they can repeat it.
Right.
And now what we're finding is that's annoying to people.
Very much so.
That if it's a 4-day trial, they're insulted when you tell them what you're going to tell them and then remind them. They're saying, I'm not an idiot. You could have just told me and I would have been out of here a day ago.
Right.
It's interesting. So how do you determine what to repeat and what not to repeat?
Well, I'll give you an example. In our second trial, our client choked to death. She was in the dining room, she choked. She had previous choking episodes, and we covered all that. But one of the defenses was that our client did not choke to death. The defense
Always
was,
is. Isn't it interesting? It's always the defense in a choking case.
their defense was that our client had some sort of cardiac event and that she just died peacefully while sitting at the table eating.
And so, it was the cardiac event that caused the throat to be lodged with the asparagus.
It spasmed, and that's why the water flew. But and the defense counsel in our case sort of laid a foundation for that defense during voir dire. An opening he talked about, or not an opening, but in voir dire he sort of laid this foundation about the difference between choking and a cardiac event. And in our opening, in Tad's opening, we had the voicemail that the nurse left for our client, the daughter of our client, on the day that our client died. So first thing Tad did, before he said a word, I believe at the very beginning, he pushed play, and it was their nurse saying, "Ma'am, you need to get up here as soon as you can. Your mother has gotten choked and she's not doing well. Please call us back." Hangs up the phone.
And you neutralized the entire defense with that.
And then Tad launched into his opening and prefacing the evidence. Well, when we put our client on the stand, we played it one more time for her to identify it. She cried when she heard it. And then we didn't play it again. In closing, we debated whether or not to play it again, but it had so much impact. The two times we did play it, we felt like if we played it again, it would lose some of its oomph. You know what I'm saying?
I know exactly what you're saying.
Yeah, when Tad opened with it, it completely debunked all of the groundwork defense had laid for it. And then when the daughter heard it and testified that was on her phone, she got it the day that her mother choked to death and died, and she was crying, we didn't need to pound that one anymore.
Interesting. Let me ask you this question. Was the closing during the same week as the opening in that trial?
It was. We started on Monday, finished on Friday.
So there's no way the jury forgot about it.
I don't think so. Tad talked about it.
Right.
In his closing, he said, "You heard their nurse on the scene who did the Heimlich maneuver 5 times tell you that her mother got choked." And so, it was really powerful in the way we did it. It's something that we learned, and it was a unanimous jury verdict. And when we did our post-trial interviews, one of the things that the jury told us, one jury member in particular who had been on juries before, said they appreciated how streamlined and direct our evidence was. We didn't beat them to death with it. We didn't drag it out. We were conscientious of their time.
Now, I know that you guys did a lot of surveys in the area. Not necessarily focus groups, but surveys where, you hired a company that sent information out. What do people think of this? What do people think of that? Just to get a lay of the land of Paducah, so to speak. Did you guys do any focus groups to see what they thought about that information?
We did not. And I don't remember how or when we made that decision. But we didn't.
I know you didn't hire us to do your focus groups. I wasn't happy at all about that, but that's for another day.
That's above my pay grade, man. You have to talk to the boss about that.
That's the only reason I know you didn't do focus groups, was actually talk to Tad about it.
It was, we did kind of get a lay of the count. It's a very conservative area.
No, it was great stuff. I saw them, and it was really brilliant stuff, because it asked things like, when you hear the name of this nursing home, what do you think? Right. And it was just really easy things, inexpensive things you can hire companies to do to give you that extra info that I thought was brilliant on your and Tad's part.
It worked out well for us. We were able to seat 2 excellent juries as far as I'm concerned.
Now, you said something earlier about cross-examination, which I want to end with, but I want to talk to you a little bit about experts, because my belief has always been, and will always be, experts don't win your case. They can only lose your case. How do you go about taking testimony of experts at trials?
On direct examination or
cross? Direct.
When I'm directing my experts, I try to prepare sort of a story. I try to avoid the standard scientific recitation of facts and standards. I try to get experts that are good at telling the story of my client, and really speaking of them in even though they've never met or treated the client, getting them to speak of them in a way as if they were their patient.
How do you do that, though? How do you get them to do that?
Yeah, I work with some pretty talented experts. That's part of it. Ones who understand and get it. And it takes a lot of preparation. It's worth the money, I think, to sit down with your expert and work with them on the story. I absolutely demand and certainly hope that my experts always retain their credibility. I'll never ask them to say or do anything that loses their credit. If they don't have the personality to tell a story, then I deal with it. But if I can get them to frame it in that way and speak about it in next logical steps and do it in such a way that lay people understand, because they've all had a loved one that's been in a long-term care, been in the hospital, and dealt with the frustrations there. I think that's the best way for your experts to have an impact, because like you said, to some extent, I guess they all kind of dismiss our experts as paid guns. I mean, it is
Everybody's experts. It's
sure.
I've always felt that if you didn't win the case before the experts, you're not going to win the case after the experts.
Very, very few experts are they're going to lay what you need to survive your directed verdict.
Mm-hmm.
They're going to prove your elements. They're going to get you past directed verdict. But every once in a while, the cross-examination will make a big difference.
Yeah. So tell me about that. What do you mean by that?
Well, again, I had the privilege of watching some pretty great attorneys cross-examine experts. The late Corey Fannin, who was a really good friend of mine that we lost last year, who tried a case with Ross Mann. I watched Corey dismantle a physician expert in an $18 million verdict case that they got that really inspired me. Corey laid an excellent foundation. The defense had hired the medical director of the nursing home to be their medical expert. And that doctor was actually our client's doctor, the resident who died's doctor. He had been her doctor for the 4 or 5 years she'd been in the nursing home. And Corey set him up perfectly in a sense that he basically established with the doctor that the doctor spent 4 to 5 minutes with the resident each time they saw them in the nursing home. And he established that this doctor had personally seen our resident 9 times in her entire tenure. His nurse practitioner saw her more often, but he had personally seen her 9 times. So he got him to admit he spent roughly 45 minutes with her. And then he got him to admit that he had spent 14 hours in the last 2 days preparing to testify against her. And it was, the way he did it was beautiful. I mean, the doctor was such a great witness on direct. I was scared to death they had just lost the trial, because he really was a good professorial, nice guy, knew the patient. But Corey systematically dismantled him, and it just was very inspirational. So I tried to use similar tactics in my cross-examinations of experts. In the first trial in Paducah, the nurse expert that the defense hired.
Now let's slow down. The first trial in the Paducah, what was that case generally about?
Okay, that was a case about a 95-year-old resident who had dementia, who was prone to, when agitated or scared, she would have violent outbursts. And the major breach in the standard of care in that case was they received an order to get this woman a psychiatric evaluation, and the nurse failed to record the telephone order and get the psych eval done. The psychiatric doctor was in the building, but they didn't have an order for this one. They had taken the order 3 days before, but it wasn't on the chart, so he didn't see the woman. She had an outburst, and they kicked her out of the facility. They kicked her out within 12 hours of the incident that occurred, put her on the streets. They didn't send her to a psych hospital. They didn't even give them a list of medications. They told the family, get her and get her out.
Are they even allowed to do that?
They are not. It's against the law, and they were cited for it. But there was a mix-up with the psychiatric hospital. They dumped her on a Sunday morning, and the psych hospital said they wouldn't take her, but then later, after the family had to take her to a hotel, it was a big mess. They dumped her, but they breached the standard of care by failing to take off a physician's order.
Okay, so it was fair to record the physician's order, put it in the TAR, and make sure something was going to happen.
Right. And
okay,
so she didn't get the treatment she needed. So then when they dumped her, it put her through so much stress. She ended up developing a GI bleed, and she died several weeks later. and she was fairly stable before that. So it was,
And this is if I recall this is where the relocation syndrome issues
yes,
came up in that trial,
that's
correct?
correct. Yes, sir.
So you've got the nurse expert. Tell me
Yes.
what you were doing.
Well, the nurse expert was a nurse that I had worked with on many cases in my career. I knew this nurse expert, and I knew she's a fantastic nurse and a really good expert. I was really surprised she was testifying for the defense, but she had been retained and she supported their case. But I knew this nurse would not give up her credibility. I knew she was smart enough. So in my cross-examination, I knew that I couldn't go in there and bicker with her because she was a good expert. She was going to talk around me and make me look stupid.
Right.
And I didn't want that. So what I did was I developed a plan with Tad where basically I got her to confirm several of the facts that supported my case and that were good. And then I developed a line of questioning based on the fact that she's a nursing instructor. Okay. She teaches young nurses how to be nurses. So I laid that foundation. And so I said to her, I said, Nurse Tramp, if you had a nurse that you were training on clinicals who took a physician call and that physician gave that nurse an order to get a psychiatric evaluation on the patient that nurse student was responsible for, if that nursing student did not take that order off and follow through to make sure that the psych evaluation was done, you would flunk that student, wouldn't you?
Ooh.
And her answer was, well, Mr. Jasper, yes, in that situation, I would have to flunk that student. And then she started trying to talk again, but the jury heard that.
Right.
That's nursing failure. When you take a physician's order, you have to follow through with it. And that's all we needed from her. And I got out. I didn't stand there and bicker with her or try to expound on it. The jury heard that and they were done with it.
So make your couple points that matter and move on.
Right. And like I said, I personally sort of categorize my questions as, is it a hand grenade? Is it a bomb? Is it a nuclear bomb?
Right.
I sort of gauge those and I get in there and I drop those. And most of the time, again, on cross-examination, my question many of the times is the testimony. I don't care what they say.
Right.
But sometimes I get them to admit, and I knew Gluanne wouldn't give up her credibility. She was going to have to say, yeah.
Well, I've used her as well. So now that I know who you were talking about.
Yeah, she maintained her credibility. She couldn't answer it any other way.
Sure. Sure. And that's so important because your hope is, there are certain experts that we all know that will say anything at any time. It just doesn't matter.
Sure.
But if you ask it in the way that you did, how does she keep her job?
Right.
And say something different? That's now, how did you come up with the idea? I'm going to ask her as if she was working and instructing this nurse. I happen to think that's a brilliant way of doing it. How did you come to that idea?
Well, I thought about my nursing school experience. I know that the supervising nurse on the floor is responsible for all of those nursing students. That's why they have to watch what they're doing. They instruct and teach them. And when I remembered on her CV that she was a nursing instructor, I wanted to put it in basic, I call it failures nursing 101. Taking a physician telephone order, writing it down, and then following through to make sure that it's executed is nursing 101. And when you fail at nursing 101, that's grossly negligent. I felt like that was going to drive our damages. Right. Because if this woman would have just gotten the psychiatric care she needed, there's a very good chance that none of this would have happened. So
now jumping to trial number 2, or actually maybe it was trial number 1. You also were cross-examining the director of nursing in one of those cases, correct?
In number 2, yes.
Yeah. Set that up for us. What was going on in number 2 and what you were trying to do with the director of nursing?
Sure. Well, going back to your discovery question earlier, one of the things, or several of the documents that I think are absolutely critical are job descriptions. I think that many facilities will have what's called a skills checkoff list. When a new nurse or CNA comes to work at a nursing home, they'll be put with a mentor or a preceptor who will check them off on making sure they can do the skills that are required for the job. That's usually in a personnel file. So I really push to get those job descriptions and personnel files for every person, because those skills are often, what they failed at doing is often found in that list of skills or that job description.
Right.
So I can use that as a standard of care. It is a nursing standard. So what I did in this case, I was reviewing the job descriptions for charge nurses and CNAs, and there was an interesting line in their job descriptions that essentially said that you have to work with the understanding that if you make errors, it will have serious consequences for the residents.
So they use the phrase serious consequences in their description.
In their job descriptions, basically saying one of the emotional requirements is you need to understand the gravity of what you're doing. You are responsible for people's health and safety. And you need to understand if you screw that up, it can have serious consequences. And to me, I read in serious consequences as injury and death. You've got people's lives in your hands. And that's what most of our cases are about our clients' lives being destroyed because of the mistakes that these people made. So in setting it up, I wanted that. It was the last question I was going to ask this director of nursing. The director of nursing had been at this facility for 35 years. She was, by all accounts and everything I could tell, a good nurse. And she seemed to be an honest person. When she was deposed, she didn't forget everything she ever did at the facility in 35 years. And I got a sense about her that if I asked her a true and honest question, I'd get a true and honest answer. And so I saved the question for last. I always try to end with a question where my question is testimony, whether they answer it the way I want them to or not, that the jury will remember. And so I set her up with a question but before that, I had laid out all the facts of the case, the facts that this facility had put my client on the wrong diet. They didn't update her diet order when they found out she had choking problems. They didn't get the proper evaluations. She choked twice at their facility. I laid all those facts out. And then on the day that my client choked, the CNA admitted in her testimony that she froze up and didn't know what to do. The nurses admitted that they thought she choked because they did the Heimlich maneuver almost 7 times. And so I set her up and said,
Wait, this is the cardiac event.
This is the one where they were saying it was a cardiac event. Yeah.
That had to piss the jury off.
Yeah. So I set her up with this question at the very end and never dreamed she would admit that the failures by her staff led to serious consequences for my client.
And we actually have the audio and the video of that. So we're going to play that right here and then talk about a little bit and analyze what you did.
Okay. As the deal went, will you acknowledge to this jury that the nursing home's failure to transcribe the order and follow through with the proper diet order, the failure to create the care plan for choking, and the failure to provide competent supervision to Ms. Talent are errors that had serious consequences for Ms. Talent?
I would say my answer to that would be yes and no, but from the documentation and the job description, but so I would have to say yes to that.
Thank you very much. That's all the questions I have.
We just heard it. Tell me about, well, let's go over that question in case it was indecipherable for anybody, even though they just watched it.
Okay. Like I said, the question in the way I set it up was I tried not to give them, obviously on cross-examination, very many open-ended questions. You just don't want them to take it off on her. She was not the type of witness that was going to take it and run with it usually. But I just basically laid all of the foundation of the facts that were, positive for our case, that showed that she choked and the failures that they made. And, I was going to just let her try to mumble through it, but she admitted that it
She sure did.
Serious consequences. And I think you see in that video, Tad's sitting there looking like, oh my goodness, is she going to answer this? And when she did, when I sat down, I'll never forget, Tad said, how did you get her to admit that? I said, Tad, I had a feeling that she was going to tell the truth.
And not only that, but the way you laid it out, fact, you would agree that caused serious consequence. You're like, wow, okay. And there wasn't an objection,
no,
which still shocks me.
I was just using their words, the words of their job description.
And I love the way you go for it. And it really doesn't matter what her answer is, did it?
It didn't. And what also blew me, when the defendants in their closing argument, the defense attorney, he gets up and he opens with, "I'm going to give credit to Brian Jasper for asking a really good question." He, the director of nursing admitted, to his question, and I give him kudos for that. But then he tried to minimize it. And I thought, I've never had a defense attorney tell a jury that I did a good job.
Well, it's tough when there's no way to minimize it. I guess he was taking a shot.
That's true.
But I love the way you think, Brian. I love the way you think a little outside the box, not crazy, but from a persuasive point of view. Why do we have to ask it this way just because everybody else has asked it this way?
Right. Well, I tried, again, and I still think like a nurse sometimes. I try to think about, if I was a nurse and I was asked this question, how would I see it? Because again, most nurses, like you said, 97% of nurses, they get into taking care of people because they like to take care of people. And
right.
They don't like it when their patients aren't well. I mean, they would, at most DONs, if their clients are safe and healthy and happy, they're just as happy as that. That makes them happy. They want it to be like that. It's
absolutely
DON. It's not about making money. It's about running a good building and giving good care. So there's one other situation in that trial, if you have time, that I can tell you about. I cross-examined one of the nurses that day. She was the charge nurse the day that my client choked to death. And this was an interesting situation. Tad and I had a discussion about, what are we going to do to drive damages in this case? Because we were worried that maybe, choking is sort of a sudden situation. You might not have extended pain and suffering, things like that. So I was trying to come up with a line of questioning that would illustrate what my client went through. So I laid the foundation with this nurse. When she got up there, she'd been a nurse for 40 years. She admitted that she did not know my client before that day. She normally worked on the other side of the building. So she was a stranger to my client, but she was in the nurse's station when they brought my client from the dining room to the nurse's station. The other nurse that was there did the Heimlich maneuver on her 7 times. That nurse had just testified and told us that my client lost control of her bowel and bladder and basically peed down the nurse's leg. She had turned gray. So with this last nurse, there was a charge nurse, I said to her, I started off my thing and I said, you testified that you've been there when 20 or more patients have died in your career. She said, yes. I said, you would agree with me that if a patient's pain is controlled and they're comfortable and they're surrounded by a loving family and they've had a good life, that death can be beautiful. You would agree with that? She said, yes. And I was calling on my hospice nursing career because death can be a beautiful experience when the situation's right. And she said, yeah, that's what we try to do. We try to give everybody, a positive death. I said, okay. So then I laid out the facts that my client choked in the dining room. The CNA froze and didn't know what to do. Another CNA took my client to the nurse's station where another nurse did the Heimlich maneuver 5 times. My client lost control of her bowel and bladder. They took her to her room, did the Heimlich maneuver again. They put her into bed. And this nurse that didn't really know her sat there with her while she died. I said, so my client's laying there in her own feces and urine, dying in the presence of a stranger. You would agree with me, that's not a beautiful death, is it? And she said, no, it's not. And then she started trying to talk. But that was it. I said, no more questions. Because I needed to illustrate for the jury that our client died in a very undignified and very sad way.
And I think too often what we do, when I say we, I'm throwing me right under the bus, is rather than do it that, we'll just use phrases like dignity. Yeah. And that explains dignity without explaining it. That's really powerful. Thank you, Brian. Again, it's Brian Jasper from the Thomas Law Office in Louisville, Kentucky, Chicago, Indiana, wherever else Tad has offices. You guys are all over the place. And just sharing with us just some ideas, thinking a little bit outside the box with cross-examination and trial. Brian, thank you. I'm looking forward to your next big verdict, and we'll have you back on.
Saul, it's been a pleasure. I always enjoy talking to you. I love when you come to town. Next time you come to town, we'll have some bourbon.
I don't think there's any question about that. We'll go to the Earl owned by somebody we both know.
Yes, sir.
Again, Brian, thank you very much. I appreciate it. And thank you, Brian. Appreciate you joining the program. And I think all of our listeners really learned a lot from Brian Jasper over at Thomas Law Office. This is Saul Gruber, your host of The Jury Thinks What, a podcast by trial lawyers for trial lawyers. And we heard today from Brian Jasper with some really brilliant ideas and thought processes on cross-examination as well as discovery. I think after you listen to this, you'll agree with me that you're going to think a little bit differently about how you present your case to a jury. And if you enjoyed this, please listen to the rest of our podcast on the Lawyer Minds ecosystem. And I look forward to speaking to everybody in the next few weeks. And if you have any questions, please give me a call. Remember, this is The Jury Thinks What, and I'm Saul Gruber, your host.
That concludes another episode of The Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.